In the case of Peter Chong and Anwar versus Khatija Binti Ibrahim and Anwar in another suit, 2018 10 MLJ 735, the High Court of Penang deliberated on a dispute concerning the validity of land sales conducted by a deceased joint tenant and whether such acts effectively severed a joint for tenancy under Malaysian law. On 26 February 1940, Muhammad Ibrahim, known as Ibrahim, took possession of a land which is located in Bandar Georgetown, Daerah Timur Laut, Penang, which he subsequently gifted to his children. After the death of Ibrahim and his son, Ibrahim's daughters Aisha and Khatija became the registered proprietors of the land. The conflict started in 1990 when Aisha had unilaterally executed two separate sale and purchase agreements, SPAs, without the consent or knowledge of her sister, Khatija. She purported to sell specific subdivided portions of the land to the plaintiffs, which is Peter Chong and others, who paid the full by mutual agreement of all joint tenants, by a course of dealing showing a common intention to sever, or by a registered instrument affecting a transfer or partition. In addition, a unilateral sale by one joint tenant without the consent or knowledge of the other, especially where no transfer was registered and insufficient to sever the joint tenancy. Additionally, the court ruled that Aisha was not allowed to sell or transfer any particular portion of the land by herself. Each owner of a joint tenancy owns the entire property, not just a portion of it. Aisha's attempt to sell a portion of the land would only take it upon herself, not on her sister Khatija. This meant that there was no property interest that the plaintiffs could claim or that Aisha's estate could inherit after her death. Rather, Khatija became the freeholder, unaffected by the plaintiffs' claims. The plaintiffs did not have any property right in possession that would supersede the legal principle of right of survivorship in spite of possessing the land for an extensively long time, having paid the purchase price, and constructing buildings on it. Rather than claiming the property itself, the plaintiffs had no choice but to sue Aisha's estate for breach of contract. In conclusion, the plaintiffs' suits were dismissed by the High Court, which reiterated that the right of survivorship in joint tenancies is the most important in Malaysian law. Moreover, the court made it crystal clear that the English common law system is not adopted in the legal system of Malaysia. Aisha's joint tenancy with Khatija did not come to an end since she did not make any legal actions, such as the transfer and success in dividing the property. For this reason, Khatija's property automatically refused to end, and Aisha's rights were not in any way impacted by any agreement between the plaintiffs and Aisha. Now let's talk about the key principles and legal findings of this case and what it means. Key legal principles and findings. Number 1 is the applicability of Islamic law. The court held that the Mohammedan ordinance, applicable at the time of the 1940 conveyance, only applied to property regarding marriage and intestacy. The conveyance was governed by English law principles, making the gift an inter vivos transaction that did not contravene Islamic law. Following that is the concept of hiba rukbah. The court ruled that even if Islamic law applied, the arrangement could be viewed as a hiba rukbah, a conditional gift with right of survivorship, which is not inherently repugnant to Islamic law. Then we have the severance of joint tenancy. Aisha's unilateral execution of the SPAs did not sever the joint tenancy. Under the National Land Code, severance required formal steps like partition or registration of the new interest, which did not occur. Right of survivorship is also mentioned. Because the joint tenancy was never severed, Aisha's interest merged into Khatija's upon Aisha's death. Consequently, the SPAs between Aisha and the plaintiffs were void and incapable of being enforced through specific performance. This case also talks about restoration of benefit. While the plaintiff's claim for specific performance failed, the court ordered Aisha's estate, the second defendant, to restore the purchase price paid by the plaintiffs under Section 66 of the Contracts Act, 1950. At the end, the judgment of this case is the High Court dismissed the plaintiff's claims for specific performance against Khatija, but entered judgment against Aisha's estate for the restoration of the benefits, monies received. The second case we will be discussing today is, as stated in the video, is CAS against MPPL and another. This case is regarding how to decide the biological father of child C. In this case, there are three important characters that must be remembered, which is defendant, one who used to work as a flight attendant. Defendant 2 is a pilot under Singapore Airlines and plaintiff, who's also a pilot, but under Malaysian Airlines. Defendant 1 and plaintiff used to be in intimate relationship with each other from 2005 until 2014, which is about 6 years. Despite having a relationship with the plaintiff, Defendant 1 decided to marry Defendant 2, which caused plaintiff to be heartbroken. As mentioned before, even though Defendant 1 and 2 were married, the plaintiff and Defendant 1 were still in an intimate relationship, and Defendant 1 even brought him back home when her daughter was 2 weeks old. After a while, Defendant 1 got pregnant, and she told the plaintiff that he was the father of the child in her womb, which makes the plaintiff happy. However, the plaintiff feels it is weird that Defendant 2 did not ask about Defendant 1's belly that has grown so much as she is heavily pregnant. Turns out, Defendant 1 admitted to the plaintiff that she slept with Defendant 2 in order to cover the fact that she is pregnant with plaintiff. The plaintiff was mad after knowing that fact, but Defendant 1 assured the plaintiff he did not have to worry about anything, because she says they will have a bright future together. During trial, Defendant 1 denied every statement that was made by the plaintiff about her telling the plaintiff it was his daughter. The issue for this case is whether the High Court, in exercise 3 of its inherent jurisdiction as parents, Patriae had power to order child to undergo DNA test to determine its paternity. It was held that Section 3 of the Civil Law Act 1956 was applicable for this issue. As stated in Section 3, English common law can be applied when there is a lacuna, which is a gap in our law subjected to cut-off dates in local circumstances. In this case, there is no existing law in Malaysia regarding the power of courts to order a DNA test on children in civil proceedings. The council argued that there is no specific law in Malaysia allowing courts to order DNA tests on children in civil proceedings. However, courts in England and India have recognized such power. The English Court of Appeal held that the High Court, acting as parents patriae, has inherent jurisdiction to order blood tests to determine a child's paternity. Similarly, the Supreme Court of India held that courts may use their inherent powers to order DNA tests in paternity cases. These authorities show that courts can rely on inherent jurisdiction to fill legislative gaps. In this case, the court held that Malaysian courts have the jurisdiction to order DNA tests based on English common law. The federal court recognized that English common law applies in Malaysia under Section 3(1) of the Civil Law Act 1956, unless modified or overridden by written law. As there is no written law in Malaysia governing DNA tests for paternity, Malaysian courts have inherent jurisdiction as parents patriae to order such tests in the best interests and welfare of the child. Even if English and Indian authorities are not persuasive, Malaysian courts may still rely on their inherent parents patriae jurisdiction to fill the gap in the law and order DNA tests to determine paternity. Under the doctrine of stare decisis in Malaysia, the 2024 federal court decision now stands as the binding vertical precedent for all lower courts, superseding the 2022 Court of Appeal reasoning on this matter. This case serves as the definitive authority on how Malaysian courts balance scientific evidence, DNA, against statutory presumptions of legitimacy. For current matters in 2026, practitioners must refer to the federal court's 2024 ruling, which effectively restricts the ability of external parties to challenge the paternity of a child born within a valid marriage. The court ruled that it had the inherent power to order a DNA test to be carried out for the child. Additionally, based on the evidence presented, the court also found that the plaintiff had successfully established a prima facie case. Final orders from the court: 1. The defendants were ordered to take the child to Hospital Tunku Azizah within 7 days to undergo the DNA test with the plaintiff. 2. If the results confirm that the plaintiff is the biological father, then a formal declaration will be made by the court. 3. The parties shall appoint a qualified child psychologist with experience within 21 days to guide the parties as to how to reintroduce the plaintiff into Child C's life and his access to Child C. 4. The plaintiff is at liberty to apply for further court orders relating to his access to Child C and payment of maintenance once the psychologist's guidance has been received. In conclusion, It is concluded that Sections 3 and 6 of the Civil Law Act adopt a double-edged application of sovereignty by virtue of laws, wherein Section 3 permits the application of English common and equity laws, provided it is relevant and applicable in Malaysia. And Section 6 does not permit English land laws, as it is essential that Malaysia maintains the liberty of its property laws. Hi, this video is from Tutorial 12 Group 13. Meet the members of this group: Kamini, Aleesa, Angel, Lilianti, and Jayen. Kamini is the leader of this group, and she oversees the group's progression. Now let's get right into the video. To begin with, in the landscape of Malaysian jurisprudence, the Civil Law Act 1956 serves as the bridge between English common law and our local legal framework. But how far does this bridge actually extend? Today we are diving into the practical application of Sections 3 and 6 of the Act. Section 3 of the Civil Law Act allows the courts in Malaysia to apply English law when there is a lacuna in our local legislation following a cutoff date which is 7th April 1956 and subjected to local circumstances in the states of Malaysia. On the other hand, Section 6 of the Civil Law Act specifically mentions that English common law cannot be applied in Malaysia regarding tenure, conveyance, assurance, or succession of an immovable property. Meanwhile, Section 6 acts as a firm gatekeeper, specifically regarding land matters. To understand these boundaries, we will analyze two cases reported in the Malayan Law Journal. The first case is Peter Chong and Anor versus Khatijah Binti Ibrahim, and Anor in another suit, 2018-10 MLJ 735, and also the case of CAS versus MPPL, and Anor, 2022-12 MLJ. Let's examine how these cases shape the way we apply imported law in a Malaysian context.
Pump it up, kitty. Just pump it up, kitty cat. Where you at? There you go. Put two paws on the floor, two in the air, and then just go. Kitty go, kitty go, kitty go. And just ride, kitty ride, kitty ride, kitty roll.